For those who keep on insisting that the Lindsay Clancy trial was only ever about whether Lindsay was criminally responsible or not, it's time to stop spinning the block. A lot of legally savvy people, including attorneys, have gotten on here and explained time and time again that although those are the most likely outcomes available based off of everything we've seen, there are more options available to the jury. But maybe you'll listen now that it's come straight from the court, who just had its formal charge conference before recessing for the day. That's where the judge and the attorneys discuss the law and the jury instructions that will be given to the jury tomorrow. We're going to recap what was discussed, including the lesser charge that Judge Sullivan has now agreed to place before the jury. So grab a drink, let's get started. Let's start with what Judge Sullivan confirmed will be included. The jury will receive instructions on 3 counts of first-degree murder under 2 separate theories: deliberate premeditation and extreme atrocity or cruelty. The jury does not have to be convinced of both theories. The instructions will also include second-degree murder. That means a guilty verdict does not automatically mean the jury found deliberate premeditation. The court will also give the standard instruction on lack of criminal responsibility. And this part is crucial. Lindsay does not have to prove that she lacked criminal responsibility. Once that issue had been properly raised, the Commonwealth had to prove beyond a reasonable doubt that she was criminally responsible when the killings occurred. If the jury has reasonable doubt about whether the Commonwealth proved criminal responsibility, the appropriate verdict would be not guilty by reason of lack of criminal responsibility. Judge Sullivan will also explain that this verdict would not mean Lindsay simply walks free. It begins a court process that can lead to her commitment to a mental institution if she is found mentally ill and dangerous. Now, the biggest development from this conference is that the judge is indeed going to give the jury an instruction for the lesser charge of manslaughter. The defense originally argued for involuntary manslaughter based on wanton or reckless conduct. Reddington then also argued that Lindsay's mental impairment and the effects of her prescribed medications could have reduced her ability to form the intent required for murder and could support voluntary manslaughter. The Commonwealth objected to a manslaughter instruction altogether. Its position was that strangling the children was conduct so likely to endanger life that the evidence could not reasonably support involuntary manslaughter. Judge Sullivan ultimately indicated that he will give one general manslaughter instruction, without labeling it either voluntary or involuntary. That instruction will allow the jury to consider evidence of mental impairment and the consumption of prescription medications when deciding whether the Commonwealth proved the intent required for murder. We will need to see his revised written instructions tomorrow for the exact language, but manslaughter is officially going to the jury as a possible verdict. There will not be a voluntary intoxication instruction. Interestingly, both sides agreed on that. They agreed that there was no evidence that Lindsay voluntarily intoxicated herself in the traditional